Can you resolve IP disputes without long legal battles? Imagine settling a disagreement over a trademark or patent without spending years in court and thousands of dollars. Sounds ideal, right? The good news is it is possible. Many IP conflicts can be resolved faster and more affordably through alternative methods. Traditional court battles are often costly, unpredictable, and take a lot of time. They involve lengthy processes, discovery phases, and sometimes even appeals that drag on 4 years. To avoid this, parties use other ways to settle disputes. These methods are called alternative dispute resolution, or ADR for short. ADR includes negotiation, mediation, arbitration, and sometimes conciliation. Negotiation is the simplest form. It involves direct talks between the parties to find a solution that works for both. It is usually quick and inexpensive but requires both sides to be willing to compromise. Mediation involves a neutral third person called a mediator. The mediator helps the parties communicate and find common ground. The mediator does not decide who wins but guides the process. Mediation keeps things confidential and can help preserve business relationships. Arbitration is a step up in formality. An arbitrator listens to both sides and then makes a decision that is usually final and binding. It is faster than court and more structured than mediation. Arbitration can be completed in a few months, depending on the case. Arbitration limits the right to appeal, so it is important to choose an experienced arbitrator. For patent disputes, administrative procedures like ex parte and inter partes reexamination allow parties to challenge a patent's validity without going to court. These are handled by patent offices and are often quicker and less costly. In trademark conflicts, parties can use agreements such as consent agreements, coexistence agreements, or licensing agreements. These written contracts define how each party can use the trademark and often prevent the need for litigation. They can be submitted as evidence in trademark office proceedings. Additionally, opposition or cancellation proceedings before the trademark trial and appeal board are administrative options to challenge trademarks without full court cases. To avoid long legal battles, it is wise to conduct thorough trademark searches before applying for a new mark. Early negotiations or mediation can settle disputes before they escalate. Choosing mediators or arbitrators with technical knowledge of the IP involved can lead to better, more efficient resolutions. Using ADR methods also reduces the need for costly discovery and lengthy court procedures. Overall, resolving intellectual property disputes without long legal battles is not only possible but increasingly common. These methods save time, cut costs, and often lead to more predictable outcomes. They help protect your rights while keeping your business relationships intact.